Get started here. Thank you guys so much for joining us today. We really appreciated this whole probate conversation. It's something that comes up a lot with us realtors and just not knowing what direction we need to go, who needs to be involved in the whole process. So we appreciate you guys shedding some light on it. If we could just start, we'll start here with Ashish. If you would just introduce yourself and tell us anything you'd like us to know about you.
Hey everybody, Ashish Lakiani Law, and one of the attorneys that works with Single Source here locally. Always here to help with all your transactions.
Good morning, everyone. My name is Davis Pereira. I'm one of the lawyers over at Hutchins Law Firm. Work with a lot of folks through probate, estate administration, and estate plan, some business work.
Deanna Coleman. I have a small firm downtown with 2 other attorneys, and I'm very happy to learn how to pronounce Ashish's last name properly.
We need a whole class on that.
Good morning, I'm Susan Benoit with Hutchins Law Firm. I manage the real estate practice for our firm here in Fayetteville, Charlotte, and the coastal regions.
Sharon Keys, I have a sole practice and I do a lot of estate and estate planning, and so I get involved in sales of real estate through both guardianships and estates most often.
Well, again, thank you guys. Really excited to learn today. So we'll just kind of go out with questions. If somebody wants to tell me what is probate, I mean, kind of explain the process and what it is, because we hear it, but I know a lot of the brokers don't really understand what it is.
Sharon, you want to start?
Oh, thank you. Well, I can tell you what I tell my clients when they first come in for, the initial interview. I tell them that probate is the process of either bringing a will forward in order to determine heirs in the estate and validating the will through the clerk of court, or if there is no will, it's an administration process. We have to file an application to open an estate for the decedent without a will. And then, we have to determine, who's eligible to be an administrator. Usually one of the heirs will come forward. But so probate is just really the opening of a decedent's estate in order to gather assets and know what needs to be distributed to the heirs under the law.
So all the real estate that they own, that's also included in the probate?
Real estate is considered a separate part of probate unless it's needed for debts in the estate. We really don't deal with it like we do with the personal property or the tangible assets of the estate. So an administrator without a will deal more readily with the personal property, the cash, the tangible assets, than they will with the real estate, unless there's a lot of debts in the estate and we need to bring the real estate in to pay some of those debts.
Okay. So the probate process, from the time they come to you and say, hey, my grandmother has passed away and we need to start preparing to sell their property. How long does that process normally take?
I'll give you an extremely lawyer answer. It depends.
That's right.
Sharon mentioned what I normally call, she referred to it as opening the probate process, and that's completely fine. We all use our own terminology. I call it the qualification process. So, but that's because an administrator or an executor under a will has to qualify before the clerk of court. So the court says, hey, you're cool, you're not a felon, you're not otherwise disqualified, you can serve, or you're appointed under the will. So that happens, a notice runs in the paper, that in the Fayetteville Observer, I'm so used to quoting costs, sorry, I'm about to say $200 unless you do an e-file or electronic payments, 207 something now, but anyway. But that runs 4 times in a row, so if it ran for the first time tomorrow, it would run every Wednesday after that for 4 weeks, but it gives creditors 3 months from the first date of publication to file a claim. So think about that in your timeline. But also 90 days after a person is qualified, an inventory is due, and that shows what a decedent owned, as of their date of death. And then within a year of qualification, an accounting is due. So it can take a year. I have some that have taken several years by design or by, holy crap, what are we doing here? But
that happens a lot.
And I never have this firm involved at all those, but no, so it can be pretty straightforward. You can be running that notice in the paper just to be able to sell property, which we see a lot of times, but unless like Sharon said, real properties needed to pay debts, or unless there's specific. Devised to the executor and direction to sell real estate, that's really not something that's inherent, so that's why a lot of your clients aren't just the executor if someone's passed away and you're trying to help them sell property. Unless they have a court order saying that they can do that, or a document like the will that says they can.
Okay, speaking with the timeline concept, so we get to the point, everything's done, you can list the property. Does the actual time the property goes under contract to closing and recording, does that take longer? When it's an estate or in probate or any of that?
Yeah, I can jump in on that
Yes,
one.
I was gonna
It has the potential to, a lot of lawyerly answers today, unfortunately, it has the potential to, because more often than not, well, I won't say more often than not, oftentimes when an estate's involved, there's gonna be multiple heirs. Multiple heirs may not always be local, they're gonna be married, they're gonna be at different places, so it has the potential to automatically involve a lot more people than just the sole owner who owned the property before their passing. So that alone has the potential to take longer just to wrangle all those necessary signatures on all the paperwork.
So that kind of brings us to a question that's not specifically put on here, but I think you guys can all of it, and I know it affects us as realtors a lot. Who all has to sign? I understand for the sale, all heirs would have to sign. Who all has to sign for the actual listing and the offer to purchase and all of that? Do all the heirs have to sign all that paperwork?
It's a question that get asked all the time from realtors that are approached with people whose loved ones just passed away and are attempting to help them sell their property. And my response is always going to be the same thing. In order to properly answer your question, I would ask that you ask the client for a copy of the application for letters, copy of the letters if it has been issued, a copy of the will if there was one, a copy of the certificate of probate if that's been issued, and a copy of the first run notice to creditors ad in the newspaper. If they can give you those 5 things, they're in really great shape to be able to move through the process and attempt to sell the property. If they don't have those 5 things yet, then they're probably not ready to list the property, or if they're selling the property, they should go ahead and tell an expected buyer that there's gonna be a delay, because those are the minimum requirements. That's what will give us an opportunity to answer who gets to sell the property. Because the application for letters will list the heirs, but the will let us know if there's any exceptional language that we would love to see that may allow the executor or personal representative to do it without the heirs. So really, it's a difficult question to just say somebody's passed away, who to sign all the heirs all the time, just the estate all the time. More often than not, it's gonna be the heirs, their spouses, and the personal representative of the estate. More often than not, but to give you the exact answer on a case-by-case basis, you really wanna see those 5 things.
So as a broker, when we get that call, we should probably ask them where
For
they
those
are in
5
that
things,
process,
yeah.
and do they have those 5 things?
Mhm.
Versus going out and
Can you name those 5 things?
Yeah.
Perfect. And did you guys think those 5 things were reasonable?
Yes.
Yeah, so the first one, which is what Sharon said starts the process, application for letters. Technically, application for letters of testamentary administration, but short is just application for letters. After you do that, the person who applies to administer the estate gets issued letters. So you apply for letters, you get issued letters. That means there's a representative of the estate. If there was a will, they would have a copy of it, and the clerk of court would approve it, meaning it would have a certificate of probate, it would be approved. And then they would run the newspaper ad. There's not always a will, so you could be application of letters, and newspaper ad. But if there was a will, there is a will, and then there's a certificate of probate, meaning the will has been approved. So those are the 5 things, 3 of which are always, and 2 of which exist if there's a will, that you really want to see if you are assisting someone who's attempting to sell the property solely owned by a deceased person as they're passing.
And in my opinion, as far as listing agreement and contract and all of that, you wanna make sure you have the owners of the property signing those and giving you the authorization to list it. Because a contract to sell property, you can only enforce it if it's been in writing. So when my dad passed away, there's 3 of us, 3 children. My brother did not want to sell the property. So we could not sell the property without him joining in, because we didn't need the money to pay the debts of the estate. So he owned a third, I owned a third, and my sister owned a third. If I would have signed a contract to sell that property and we come to closing and my brother won't sign, I can't sell the property. Same with the listing. If I agree to sell the property for 200,000, but my brother says, I want 250, where are we at? So the point of getting all of that done early and knowing what's out there, if you are doing a listing, talking to somebody that can help you, is who needs to be involved.
Absolutely.
And it's important to try to identify that early. What I'd suggest to a lot of agents is out there, when you're speaking to a potential seller, go pull the GIS, go pull the tax card, go see what's out there, see who the owners are that are listed. If they're alive, you're probably in fairly good shape, but if you know somebody is deceased, then you need to start asking these questions and start doing all of these things early, because probate's not a swift and not a quick process for folks to go through. And a lot of times there's a lot of pressures on sellers. There may be a mortgage on the property that maybe the new owners can't afford to carry for 6 months. There may be, nobody knew mom and dad had a mortgage on the property, and could be a pending foreclosure and some other things there. So it's really important to try to identify these issues early, because if they're identified early, then we can do as much as we can early to get it to closing as soon as we can.
To expedite the process. Okay. So what are some of the typical challenges that we as realtors that you guys kind of help us solve with that we face? What are kind of some of the typical challenges that come when selling an estate?
I think for me, and I don't mind helping out under emergency circumstances, but a lot of times when I get the call, the estate either hasn't been open at all or was open and something hasn't gone right. But if I have to help someone who has a sale pending, and it could potentially, if you have buyers who aren't willing to extend, if we can't get someone qualified to run the notice in the paper in time for closing, then closing is going to be delayed. And there's really nothing I can do about that, because to Davis's point about things not moving so quickly all the time, our clerk's office is getting more and more backed up. So even these initial filings are taking longer to get back. And then you have to have availability to run in the correct paper, so it's not instantaneous.
So kind of just, that kind of goes back with what Ashish was saying with the 5 items, so as soon as we get ready and we send a contract to the closing attorney, we should probably let them know, hey, we have a copy of these and here are these items that we checked in that would help expedite the process as well.
Go ahead.
Another potential delay, and this a lot of times is a substantial delay, is if somebody passes away and one of the heirs and one of the owners is a minor child. So, that is certainly something I suggest people to try to identify fairly early in the process. The reason for that is a minor just can't sign a deed. You either have to petition the court to sell it, or if you can pull the real estate back in to sell it because there's not enough assets to pay the debts. There's a number of ways to do it. But at the end of the day, any sale, a Superior Court judge has to sign off on that sale if there's a minor, if hasn't been a guardian appointed. And there's a lot of steps in that process. And I defer to Sharon on the guardianship pieces of all that. But that of the delays I've seen, that is one of the largest delays, because there's just so much you're waiting on the court system for.
Hang on, and the newest thing that they've come out with now is if you're selling through a petitioning process through the courts and a bond was in place either for a guardianship or an estate, they want you to increase that bond to the amount of the proceeds that are coming in, and they will not sign the order until that bond's been increased. I just got an email on one of those just the other day.
Yeah, and can you expand a little bit on the guardianship sale, the whole process with that one?
It is very similar to
Okay.
when you're doing it through an estate as well. If you have either a minor child or an incompetent adult, the guardian would have to petition the court to give a reason to sell the real estate. And there's a hearing, and the clerk, if the clerk feels that the necessity is warranted, then will issue an order. And it'll also go through the same process that the estate would go through with the upset bid and, the report of private sale. And then, of course, you have to have the final order signed by both the clerk and the judge. And that's where the bond issue comes in, because any estate that's doesn't have a will, or a minor or an adult guardianship situation, usually you have a bond. You have a bond issue because the person that's either the guardian or the administrator has to be protected, for the value of the assets. And so if the assets are going to increase because of this sale, then they make you increase the bond before they'll sign the order. That's their newest thing.
You mentioned something like the upset bid. Can you kind of discuss or share with what that is, what that process is?
Sure, once the clerk orders the property sold and we have, let's say we have an offer already. Then we'll do what's called a report of sale. We'll put it into the clerk showing the offer that's been presented to either the guardian or the administrator. And then once that report of sale is filed, anyone in the community has the opportunity to bid over that offer price. And that will keep going for 10-day increments until someone bids the highest and no more bids come in. And then that person actually has purchased the property. And the clerk will sign the order for that particular bid.
And that happens with the guardianship.
It happens with both the an estate administration and the guardianship if you're petitioning the court.
Okay, so when someone would pass without a will and it becomes an administrative process, is when the upset bid happens as well, or?
Yeah, well, either whether in a probate estate, whether you're bringing in, if you're bringing the real estate for debts, it goes that way either way, whether it's an administration or whether it's a will.
Okay, so it's when the real estate's necessary for the debts, okay. So that could be a delay too, because if the 10-day period, that could, get quite lengthy, enough 10 days start add on, so.
Right, and if you have a contract, you're representing the buyer and they made the offer. If their bid gets upset, Deanna becomes the new purchaser of the property because she upset the bid. Similar to a foreclosure sale. It can be upset over and over and over and over again. And then the last and highest bidder is the one that gets to purchase the property. If they don't come through with the money and they don't purchase the property, it all starts over again. You can't just go to the last bidder. You have to start it all over again.
So those are definitely things that could delay the process if someone was purchasing a home that was being sold in that manner.
And it also delays it for the seller because they can't do anything to it until it's done. Another thing that could delay it for the seller, I'm sure many of you have seen, like when David said, look up the tax bill, see who's the record owner. If it says Willie McNair heirs, and it has said that for the past 12 years, that means he's been gone for at least 12 years. There's a possibility that his heirs have gone. And so then you go from having to have his estate addressed to having his brother's estate addressed or his son's estate, whatever it may be, or theirs. So you might go from Willie having 3 children and their children inheriting the property to Willie having 3 children, one having predeceased who have, 7 kids. Their 7 kids inherit the property. So you keep it becomes a pyramid that you have to build on.
I have over 52 heirs right now.
What
a journey. Wait, okay.
I would recommend a power of attorney be done at the very beginning, which a lot of times I would recommend, so you don't have to send documents back and forth over and over. Just make sure that power of attorney is specific and it gives whoever the agent is the right to list the property, to determine the amount of the sale of the property, to sign all of the documents that might be necessary to sell the property, all of that. Don't just do a real general one.
And adding on to Susan's comments, I suggest to my clients when they're working with their realtor and they're putting in place a contract, if we know we're going to have upset bids and, a court proceeding, I always suggest to them to put the timing clause about when closing will take place, but after order by the court. And that way it gives them leeway as to, not having, like she said, that crunch date, and then you're gone beyond that because of all these upset bids.
And how does the administrator get specific power of attorney? What's that process?
Have an attorney draft it.
And all the heirs sign it?
And their spouses.
Yeah, heirs and their spouses. That's right. Because again, going back to the situation with my family, my brother didn't want to sell it, so his spouse wasn't going to sell it. But if my brother finally said, okay, and his wife was like, no, it's worth this much more, so I'm not signing. She has a marital interest. She has to sign. So anybody that might have to sign it, I would get one.
Wow.
So the same rules would apply, say for example, your brother was divorced, but when you inherited the property, he was married.
No, that doesn't apply because a spouse only has marital interest while they're married. Okay, so if he inherited while he was married, they divorce, she no longer has an interest in that property, unless she's already made a claim through equitable distribution. If she is doing a domestic action and she has already made a claim, then she may have an interest. But once the divorce is final, if she hasn't tried to make a claim, she doesn't.
You mentioned power of attorney, and this may or may not be, but so correct me if I'm wrong, but a lot of times we're seeing with estates, it's usually dealing with a lot of elderly people often. Power of attorney, would that work for people who don't use electronic signatures and stuff? I mean, I've seen situations where we've sold estates and, you know, they live down in Florida and they do not use internet, they don't use email, so would power of attorney satisfy being able to not have to mail it to them every time they needed something signed?
Yes,
Okay.
yeah, I mean, they'd have to sign that original power
Right,
of attorney.
exactly.
And bring it back in a wet signature with the notarized statement until we get our electronic notary laws finalized. But until then, yes, and then they can just, if I am the power of attorney, and I wouldn't do it as the attorney, but let's just say it's in my family. If I am power of attorney for my brother, I would discuss it with him, and then he would say, okay, I'm good with it, then I would sign it. Because then I have the authority to do it, and I just wanna make sure he's good with it, you know?
Right, but I just seen that as another delaying thing when you're dealing with people who cannot use electronic signatures, they're not comfortable with it. You know, the expense of either overnighting it or the delay of sending it through snail mail.
Yep.
So that can be an error. How does, and we've touched on this a little bit, but maybe there's something you'd like to expand on. How does probate impact negotiations and the offers on the property? One of the things you mentioned was that the clerk of courts has to approve the offer to purchase. So how does that affect negotiation?
I don't think it generally does. The clerk pretty much, unless the offer is like way off base, when we go to the hearings and we have an offer, I mean, usually that's not an issue with the clerk. It's just sort of a formality to get the ball rolling.
And let's not forget that the procedure that Sharon was talking about is only a small segment of those sales that involve a decedent's estate, where the court gets involved either because the personal representative takes control or because of a guardian. More often than not, at least more often than not, I see the heirs amicably, well, somewhat amicably sell the property together, and in those instances, the court's not involved in the process at all, as long as everybody is in agreement in terms. So the biggest thing that you're asking there is, the biggest impact of negotiation is wrangling all of those people's differing viewpoints, you know, and there's a lot of emotion involved in the passing of a loved one, the value of nostalgia and where you grew up and your memories and things like that. Some spend more time, some spend less time. All those kinds of emotional factors have a big impact on the value somebody holds for a property.
So hearing what you're saying, one of the questions is, what are the responsibilities of a realtor when representing a client involved in a probate sale? One of the things, and I'm hearing you say, is it's probably best up front to meet with all the heirs and have that actual listing appointment, if possible, with all the heirs, whether in person or on Zoom or something. It sounds like that would kind of forego some of the hiccups along the way. Is there any advice you can give on that?
Go ahead.
I certainly don't think that could hurt. I think part of the battle is just identifying who those heirs are early. I also think it's important, especially when you're dealing with an estate, is to be upfront. And this is certainly something the realtors on each side can do, is communicate that there is an estate here and there may be delays. I mean, just because you've made an offer and the buyer wants to turn that sale around in 30 days, that may not, even if it's a cash offer, that might not be possible. So, you know, certainly probate's not, like we harped on a number of times, it's not fast. And so being upfront with the buyer saying, hey, we're trying to work through this, we're trying to get this stuff approved by the court, if that's needed, and communicating it. It may not, we may have to push a closing date back. You have to work with us on time. So communicating that to the buyers is common. I commonly get calls from sometimes buyers agents or even the buyers themselves. Hey, what are y'all doing? We were supposed to close 30 days ago, get it done, but you know, because nobody has said anything to the buyer about that and explain the reason for the delay.
So that's a great segue to the next question they have. As a realtor putting listings in the MLS, should we be identifying or saying something different than we would on a traditional listing when we put it in the MLS?
Absolutely, I think, so I mentioned the 52 heirs, and that's the real number, but I'm the administrator of that estate, and I've hired a company to determine the heirs before I ever thought about trying to sell it, because I had to petition the court, try to serve these people, serve people we couldn't serve by publication, so on and so forth. So by the time it came to sell the property, I was ready to roll, when I found a realtor to help me, but we have prepared, and I don't think there's a disclosure form yet, but when there's a judicial sale, we always make sure we tell the realtor to say that it's a judicial sale in the listing, so that that's very clear. Don't say later, hey, you didn't tell us that this was subject to an upset bid, for example. And then we require an addendum to the contract that also acknowledges that it's subject to upset bid because it's a judicial sale. So that's been helpful in the past, especially with that whole thing where, hey, it doesn't close on time, well, you already knew this was happening, so. But I like your suggestion, Sharon, about after the court order too.
So when we're putting it in the MLS, we always put the owner of the property. What is it that we would put when it is an estate sale? Do we put the estate of Mary Smith? Do we put the executor's name in there? Who do we put in? Who, if there's 52 heirs, that would be very hard to get that on an offer to purchase. What do we need to put in there to identify the owner correctly?
So, and I will defer to everyone else too, but in that example, I think the appropriate party is me as the administrator, because the court has already determined I have the authority to sell, so I'm the client for the realtor. But I think the answer, in my opinion, would be figure out who your clients are. So is it a consent sale like she was mentioning, excuse me, or is it something else? And it's the people who are the owners of the property, as Susan mentioned. It's what I think.
Yeah, so the heirs of the estate and maybe the executor, like Deanna said, if you have already gone to the listing and you've gotten some information and you've told them, okay, this is what you need to do, you need to go get this set up. And that's how you're gonna determine who the owner of the property is, or if the executor has the right to sell the property. Then you can list Deanna Coleman, executor of the estate of.
So we would give her title after, like Deanna Coleman, executor of estate of Susan Smith or whatever, okay?
The most important thing is you don't list the decedent as a seller. Say the decedent is John Smith. The seller should not just say John Smith. That doesn't give any connotation to the fact that John Smith is deceased, and if you have no reason to believe John Smith is deceased because on his face, John Smith is the seller that signed the contract, you'll cause a delay in and of itself because somebody might not be looking for the estate of John Smith because the contract purports to be signed by John Smith. So the estate of John Smith automatically gives the indication that the person is no longer living. So at a minimum, the estate of a deceased person should always be included if you're referencing the deceased person's name.
Talking deceased and this is in probate, how about when a couple's married and it was owned, all the records, the tax records, the deed and everything, say John and Mary Smith, Mary's deceased. Do you just put John Smith on it, or would we put John and Mary deceased Smith?
If they owned it, if on the deed they owned it as husband and wife and spouse, and at the time of the passing of the spouse, they were still married, then just the surviving one is generally the sole owner without any need for any estate administration, usually the death certificate showing that they were married at the time of their death to the person who survived them is enough for them to sell the property solely.
Okay,
So no reference to the deceased spouse should generally be necessary there, as long as they were still married to each other. We've seen weird quirks like they got divorced and then they got remarried. That defeats all that, but that's a really small percentile of the things that can exist in that situation. So it's not something that we use as like a bright line rule there, but generally speaking, if then they passed, they were still married to each other and they hadn't previously been divorced from each other, then just the surviving spouse is fine.
okay,
And something not in the spouse realm, if you have the deed where the property was deeded to Susan Benoit and Carlos Rivers, that's my brother. We both own, or joint tenants with right of survivorship. If I pass away, it becomes my brother's property. My spouse doesn't have to sign anything because he doesn't own it. He never owned it. He had a marital interest in it, but he doesn't own it. So if I go to sell it while I'm living, my spouse has to sign. But if I pass and my brother is selling it, he doesn't need my spouse.
So when you said on the contract, we need to put the heirs on there, what about the spouses because they have marital interests? Would they need to be on there too? So if you have 3 heirs and they're all married, it would be the 3 heirs and their spouses on the offer to purchase and the listing agreement.
And the estate.
And this, okay.
Yeah, the bigger the blanket, the more it's gonna cover your,
Gotcha.
So I would
I'm
give-
all about covering that, all about, so, okay. What are the legal risks that a realtor needs to be aware of when they're dealing with, probate property?
Basically, if we talk who has the authority to sell the property.
Yeah.
You know, creating a contract that's binding. That everyone who is an owner or has an interest in the property joins in it, so that the buyer is not putting out DD to someone who's a fraudster. Or someone who hasn't talked to any of their siblings, someone who steamrolled their agent by saying that they have the letters and they can handle it all. Regrettably, oftentimes the person who gets the letters, I get approached by agents who say they're being steamrolled by the executor who says. This one piece of paper and they're just waving this piece of paper, says they're allowed to do everything and no one else needs to be addressed. Then they get a DD check and it gets payable to them directly and it all falls apart.
So do you recommend that realtors obviously pick up the phone and call one of you guys and say, hey, this is what we're dealing with? You know, what direction should I go? Because I can see them coming and saying, oh, I've got the paper, I'm the executor of this estate, here it is, it says it, and the realtor, we go ahead and list the property, taking what they said at face value.
Yeah, I field those calls all the time. Realtor picks the phone, hey, what do I do here? And usually it's a 3-minute conversation. I'd much rather address it day one than 2 days before closing. So, you know, that helps a lot. Sometimes a 5-minute phone call can not fix the problem or at least point you in the right direction to do that. You also talked about potential liability to whether it's real estate commission liability or just litigation liability to realtors. I would say just be careful how things are disclosed. Make sure that there's not any misrepresentations being made. You know, make sure you're communicating clearly. You know, for instance, as Ashish mentioned, don't list the deceased person solely on the contract as the seller. You know, make sure it's the heirs of the, heirs of the estate of John Smith, those kind of things. Just make sure what's in MLS, what you're telling the other side, just communicating openly and clearly and informing them of the potential pitfalls, because if the buyer knows what's going on and the buyer can expect that it may delay it for 60 days, you know, there's much less likelihood of hard feelings or potential liability there.
the other thing I would say too is follow up with an email or something like that, where you state, I am not an attorney, I'm not giving you legal advice, this is my experience. I would suggest you contact an attorney, or we contact an attorney to verify and clarify, because you don't want to be accused of the unauthorized practice of law if a seller says, well, you told me this and I expected that you knew it because you're an expert, and you know what I mean? So it's something like that you might want to consider doing as well.
That's a good point, because once we give that advice, they're gonna immediately say, like you said, well, you said, so no, that's definitely, a lot of times then, like they said, you know, they come to you, they come to us wanting to navigate through the process. What is the number one thing that we should tell them that they should do first?
Talk to your lawyers.
No, but some of them are gonna self-serve. Some of them are gonna self-serve regrettably in amicable situations. They may not always, it's the situations where the estate's not so grand, they may attempt to self-serve. So just, I mean, if the 5 steps.
5 steps.
If every realtor checks the box on the 5 steps before it hits the MLS, there'd be far less controversy.
Can you
down the
repeat
road.
those again, and Ruben, if you could you type those, do you have a keyboard?
Yeah, cause you text Sony when you saw the question.
Yeah.
She texted me that you text her.
Yeah,
Can you text me?
I'll just forward you that.
Yeah. that would be great.
I saw the question come up on the screen.
But
I didn't
yeah,
see
that's fine. But since you brought them up
It'll be in his inbox in just a second.
I have a band over there.
So everybody who had asked for those 5 things, we're gonna type them in the chat box where you hear in a moment.
Yeah.
So, How often do the laws for probate change? Is this something that as realtors, we need to really pay attention to because they change often?
I would say they don't change all that often. I mean, there's certainly changes, little tweaks here and there. The legislature changes. But I would caution you that although that our statutes that the General Assembly makes don't change, sometimes our local rules change. I mean, in county by county, in some counties, the clerk's office wants you to do it this way. And in other counties, you better not do it that way. You've got to do it this way. And that's just because we've got different clerks' offices, we've got different interpretations of the law. There's a governing body, the administrative office of the courts, that tries to counsel each clerk's office, but everybody interprets things differently. So one thing that flies in one county may not fly in the others. So I wouldn't say that our probate law changes drastically year to year. I mean, there's obviously changes and updates we do, but I certainly would suggest to you that just because this is the way they do it in one county is not the way they do it in another. I kind of say there's two types of law. There's the statutes and then there's clerk's law, and we've got to follow both of them however we do it. So sometimes we've just got to do what the clerks tell us to get it done, and that's part of what I see that changes most often is how the clerks interpret the different laws and statutes.
And Davis's information leads me to another point. If you have a guardianship or estate in one county, but the property is located in another county, you have to start it in the county of probate or guardianship, but things get in the process, it gets transferred to the other county to finish it off. So you're gonna be working with two different counties if you have that scenario.
Or two different states. If the decedent died in New York and that's where their estate has been probated, that's great for New York property. It doesn't do anything for North Carolina property. So you have to get some of those estate proceedings. Yeah, they have to do an ancillary administration or get some of those estate documents filed in the county where the property is located. Because that's where you're looking for the proof. Me as an attorney, when I want to give the property or convey the property to the next person, Paula's buying it, I need to certify to her that all of the heirs in the past were part of this transaction, so she has good title.
So question here on someone who is deceased and they've left a will. And they specifically say they're going to leave the house to their son. And they have other children, but the son gets specifically the house. Do the other heirs have to sign for that house, or is that something that all of these 5 items and stuff would let us know? One of those items would say that only the son is responsible for selling the home.
So depending on the language in the will, if there is a specific devise of real estate, if it doesn't say I devise it to my executor and direct my executor to distribute it, for example, if it just says Johnny gets this house, then when that will is admitted to probate, so when the clerk says, yep, this is all good, thumbs up, and issues letters testamentary, title of that real estate vests in Johnny. But if the estate administration is still open, what I have seen is that, the estate holds on to some interest in that real estate so that it could take Johnny's interest if the real estate needed to be sold to pay bills. So you can tell me I'm right or wrong, but a lot of times, even though there's specific divides, if an estate's still open, they might want an affidavit or something, maybe not, but
They have the estate joining the deed.
Yeah,
Often.
and we'll
They
get
indemnity
an
agreement.
open estate indemnification agreement. Which is where the executor, Deanna, says, yes, Johnny gets the property, I don't need to take it from him to pay the rest of the debts. I have enough.
So once that happens, Johnny could sell the house and the estate still be going through the administrative process, but they could liquidate the property, or Johnny could, because that wasn't necessary to pay the debt.
Yeah.
Okay.
So I think to your question, where the deceased person had a couple of kids, Johnny was just one of those kids. Then that set of facts, the seller would be Johnny, his spouse if married, and the estate of the decedent, so that the estate releases its interest that it may have in attempting to collect for debts and such.
So
And not the other children, they could be omitted from that one.
so then the person that's going to sign for the estate of would be the administrator of the estate. Yeah, okay,
As long as the estate's still open. If the estate's already been opened and closed, you don't need the estate involved anymore at all.
because it's
It
already a
should
done
not.
deal, okay, okay. What other questions do we have here? We have a few more minutes, I'm sure you guys got lots of good questions.
You mentioned earlier that the executor has to qualify or not be qualified. Could you explain those, both of those, what would qualify and what would disqualify?
I use words, but you're welcome to take it.
So qualification is somebody applying to the clerk's office, filing an application, an oath, and there's other forms that sometimes have to be submitted based on the type of estate that's being opened. And you submit that application and then the clerk's office reviews it, whether they're the named executor in the will or they're the next of kin that's applying to be the administrator. Qualification is the clerk's office actually issuing what's called letters of testamentary with a will or letters of administration without a will. So it's qualification is the clerk's office putting their seal on those letters saying, you, Davis, get to be the personal representative of this estate. It's applying in the clerk's office, accepting the personal representative as in charge of the estate.
Got you. So if there are multiple siblings, is that assumed to be the eldest child, or is something that necessarily has to be agreed upon by the state for lack of a better word?
So there's a statutory hierarchy of who gets to apply if there's no will. If there's a will and the will names an executor, then they get first right? But there's a statutory hierarchy, usually starts with spouse and then children, then grandkids, and it goes down the list to creditor, includes creditors and any other interested person who may apply to be the administrator. Children are on an equal playing field. If more than one or two people, if all three kids apply to be the administrator, then the clerk's office decides who's going to be the administrator. There's a hearing held and there may be, one of them may be disqualified, and one disqualifying factor that's, I find commonly if somebody's a felon, you can't be the administrator if you're a convicted felon. So, you know, that can become a mess. Sometimes the clerk's office will appoint co-administrators. If there's a lot of fighting, they may choose somebody or somebody else.
So even if they're the sole child heir, if they're a felon, they could not,
Generally speaking, they're disqualified. There's a statute that specifies that that's one of the disqualifying factors to be the administrator of the state.
But that's only necessary when there needs to be an administrator. If there's a will, they can name a felon to inherit the house,
Inherit, yes, but not.
That's to be the personal representative.
but only if it has to go through the administrative process, would that be an issue? If I'm understanding you correct?
No. Every open estate has to have an administrator, not
Okay.
just because of a court approved sale.
Oh, okay,
Administrator has to handle the duties or the administration of the estate, personal representative or executor, executrix. They're saying that the felon cannot be that person, that point person for the estate. They can be the Johnny in the set of facts that gets the property, but they can't be the person signing for the estate that also needs to participate for so long as the estate is open.
okay.
And some lessons are learned the hard way, and speaking from experience, but a convicted felon whose rights have been restored can serve in that role. And then it becomes the definition of what does it mean to have your rights restored. It doesn't mean you can carry guns again, but if you have served all your time, paid all your fines, you actually have your rights restored. You can try, you can start voting again. You can't automatically have guns again. But anyway, I learned that through a very complicated case. So, there are ways felons can regain, there we go, their right to serve.
One other thing I just want to touch on is the speed and the pushiness of sellers or whatever. Just like with your wiring instructions and information like that for closings, if you have somebody that is pushing you too hard, too fast and wanting it like this, question it. Something may not be right. If I am working with a buyer and they've gotten wiring instructions and the person is saying, I have to have this money today, I have to have this money today, or it's not gonna fund in 3 weeks, or it's not gonna close in 3 weeks, there's a problem with that. Somebody's being too pushy, and that should bring up a red flag. The same with the seller. If a seller is saying this has to happen, this has to happen, why? Why does it have to happen? If there's a foreclosure pending, like was mentioned earlier,
Yeah.
So if you're getting pushed fast and hard, put on the brakes.
Yeah.
Get
So
some
that's
more
it.
information.
So that's another thing that's going on, is someone trying to sell heirs property that they're not really the heir for the property.
That's right.
So is it best to have, when you have an offer of purchase, just have earnest money, not due diligence money, because that could be messy, I don't think. Because who, if there's due diligence in the offer.
Who's asking, the listing agent or the buyer? I mean, the question coming,
Buyer.
yeah.
Buyer, person, buyer.
If you're doing the buyer, you want earnest money. And that, in my opinion, is all the time, no matter what, it's anything. But if you're doing the listing side, you want due
You want all due
diligence.
diligence and only due diligence. Not as much due diligence as we can get.
It may be able to, if you got multiple. If you got more, say you got 3 siblings.
If an attorney's weighed in on the 5 things,
Uh-huh.
then they can give you that direction, because the same people that are named as. More often than not, if your 5 things are multiple heirs and the estate's coming along for the ride, the multiple heirs are the ones you split it up with.
Okay.
Yeah.
So in a case like that, would you recommend, so we're gonna do due diligence, would you recommend that the due diligence comes in 3 equal amounts, let's just use an easy number, $3,000 due diligence, 1,000 to each of those 3 heirs, or would you ask the attorney to hold that money? How would that be the smoothest, less messy when you're dealing with an estate with due diligence money?
I would say 3 pieces, give it to them, because I'm not gonna hold due diligence.
Okay,
we
Yeah,
don't have-
that just puts me in another position where I have to be liable for a disbursement that didn't relate to a termination.
okay,
And if an estate is open, you can make it to the estate and they can hold it until everything's resolved and finalized, and then they can disperse it.
But we get a lot of pushback on monies paid to the estates as closing attorneys. And the taxes that the estate has to pay as it relates to these monies that were never a part of the estate in the first place,
That's
regrettably.
true, that is
so
true.
ideally it is to make out a due diligence check to each of the heirs.
What do you guys think?
Yes, because ideally you know who the owners of the property are.
That the heirs are selling it.
Okay, okay.
Cause like
That
Deanna
makes
said,
sense.
upon the passing with the will, it vests in the ownership vests in the devisee of that will automatically.
Okay, makes good sense.
Did you have a question?
I did. I wanted to ask, I like to, as best I can, bring you all, the attorneys, whatever I can find on my own before I do anything. Can the file items, can I verify those myself and like put them in a nice email and send them to you? Or is that something that?
Will the estates division allow a civilian to go copy the files?
They're public records.
Yeah,
Yeah,
but-
absolutely.
I would even say if you're the listing agent and you know there's an estate open where your client has an attorney, the estate attorney's gonna have that on file and be happy to send it to you, but sure, if that's not the case, then.
but
That's
you
right,
can't get
and-
it online. You have to go to the courthouse to get estate documents.
Right now,
Right now,
Ah,
yes.
see.
Yeah,
as
yeah.
of November, they allege all of Cumberland County.
Alleged keyword there. The keyword there.
Has anyone tried to get documents through Odyssey from the counties that are already on
Yeah.
Odyssey? I can't figure it out.
I've gotten some from
Yeah.
Barnett County. I don't do some of the other ones,
It would
you know.
bring me to the actual, stuff that's been uploaded.
For those of you that don't know, Odyssey is the new computer system or case management system that North Carolina is moving to. For, I don't know, since I started doing this back in 1992, we used a DOS system called VCAT, where I could look up information and then I could send somebody to the courthouse and pick up copies of documents and everything like that. But we're moving now to this program that is online, and you'll be able to see the documents online, which in the counties that we've done stuff in, Harnett County, we can pull a copy of that immediately. but it is so finicky. You have to enter the name exactly right. If you do Benoit, comma, Susan, without a space in between it, like we've always done in BCAP, it's not pulling up anything with my name on it. But if you do Benoit space Susan, it might. If you do Benoit, comma, space Susan, it might. If it's like an estate, it might. There's so many different things, so you can try, and if you find something, that's great. But ultimately, the attorney's gonna be the one responsible on the clear title part, and that's just great for us.
And another note on Odyssey is that is gonna, they rolled it out in parts across the entire state. Cumberland County and some other counties in our area are supposed to be rolled out in November. So just so you all know, that is going to be a huge delay in our court system, especially in our estates division, which is already overworked. So just so you all can be prepared, if you've got any closings that are waiting on estates, it's gonna be even slower probably for the next 4 to 6 months while our clerk's office gets their head around how to take everything that's been in physical files since the beginning of time to go online.
And something you might want to tell your clients too, on when that happens, they will at closing sign another document that they're not used to seeing. It's like an indemnification and a hold harmless type document where it states that they understand that this system is new and something might get missed. And they're going to indemnify the buyer or the title insurance company for that if something comes up. So basically, if I'm selling the house, I'm going to certify that there's no pending action against me. And if there is, one pops up that I didn't tell you about, I'm going to step up and protect it. And that's a title insurance requirement.
Sorry, but with the Odyssey, is that when you say it's the new system, that's the only way you're gonna be able to pull records, or I can still go physically in person to pull these things? Or is Odyssey just like
Still
now
pull
we only
person.
can do
Or you
online?
can still pull a person. They're gonna create a hard copy, aren't they, or no?
No,
No?
it's all gonna be online. Every county differs a little bit, but most every county is solely online. There's not gonna be physical files anymore in the courthouse.
But that'll only be moving forward. They're gonna be a while before they go back and add
There's,
the previously administered and closed estates. That's gonna take it.
I think the hard copies that are there and that are saved in Raleigh and all of that for however long they have to keep them will be there. But when Cumberland County goes to Odyssey, we will no longer be able to access anything from BCAP. Everything from the past will go there. What I picture will happen in the estates division or the civil division, just like register of deeds, when we used to go pull all those books and all of that. Now they have like 4 or 5 terminals. What I picture for public record purposes is there'll be 3 or 4 terminals that you can look stuff up on. Or the clerk can look up stuff with you. I don't know for sure how it's gonna happen, but you have to be able to see it because it's public record.
so I'll give you an example. In a lot of the counties that are on Odyssey now, in litigation cases, we used to, when we were in a lawsuit, we used to hand up a paper order to the judge who would sit up on the bench and sign the order. I cannot walk into court with an order anymore to hand up to the judge. I have to email it to the trial court administrator or upload it to Odyssey, and then the judge e-signs it on Odyssey. So, I mean, they are trying as hard as they can to get rid of paper.
Modern technology. So, does anybody else have any questions? Like,
What, from y'all's perspective, what questions have we not asked that you think we need to know?
And the biggest thing we didn't talk at all about is claims. I don't think the word even came up in our hour conversation. In claims. We talked about, I think, question 1 of what has the potential to cause delays. Claims has one of the biggest potentials to cause delays. Cause it's like, when you have your seller didn't tell you about the judgment. You know, they told you about their mortgage, but they didn't tell you about the $30,000 judgment in favor of Ford Motor Credit. That we closing attorney tell you when we run the judgment search and we say, were you tracking this $30,000 judgment against your client in favor of Ford Motor Credit, that they didn't factor into the net proceeds sheet, and now their numbers really don't work and they can't sell the property. Those claims have the potential to be that same kind of conversation too. You know, sometimes there's more than sufficient enough money in the estate to cover those claims, but they're not paid yet. they're not paid yet, it gives a lot of anxiety to the title insurance company, so it has the potential to be a real delaying factor.
And I'm gonna pick on my brother again. First of all, he's a great person. He's and all of that. He's just always my example. So my father passes away, the three of us inherit the property, but my brother had a credit card that he didn't pay back in, less than 10 years ago. And they filed a claim, or he got a judgment against him for $3,200. That $3,200 attaches to his share of the property. So even though he wasn't the owner previously, he's an heir, immediately upon death, he becomes, or that judgment attaches to the property.
I have seen that in the state deal with tax lien. One of the heirs has the tax lien, and that tax lien immediately gets attached to that heir with that property.
Yep.
Yeah, so that is another thing with the heir. So again, another thing about what we should know is there any things, because we always think of the property or the deceased having, a judgment against them, but what judgments might the heirs have against them? So that's a whole nother avenue. Any other questions?
I think just one thing I might add there to your question is, what was in my head when we were talking about know who your client is, it's not, in my mind, unreasonable for realtors to think this person is the executor of an estate. Of course they can sell the house that was the dead person's. And just remember, in estate administration, that up is down and right is left, and it just is, nothing is what you think 9 times out of 10. But in order to protect yourselves and your licenses, right, just make sure that, even people who aren't so pushy are just like, hey, I'm the executor, let's roll. They might not have the authority to move forward, and then they're signing a contract saying they do. And what does that do for y'all from a liability standpoint? I don't really know the answer to that, but it's just bad business to do.
And so I do have one last question. These 5 items that we've referred to, will that prevent the fact of someone coming up like there was a divorced spouse or something, all of a sudden trying to upset the claim, like right at closing that they have interest in the property? As long as these 5 items have been done and checked, that's going to end the opportunity of somebody else trying to come up and have claim on a property?
No,
No, okay.
no, this is just the initial groundwork that you like to see to think that things can move in the right direction.
So
There's
all the way
always
through.
an opportunity for the other shoe to drop.
Okay.
Anybody can make a claim. I can go today and file something at the courthouse making a claim against property that you own. Doesn't mean it's valid, but it's gonna slow it down.
Okay.
We're gonna have to figure out why I did it and have somebody say, insurance company, I'll insure over that or something like that.
The non-Johnny siblings could dispute the will or contest the will. That can happen after those 5 things occur. That can
Okay.
happen right before closing. The shoe can always drop, but these are just the baseline things.
Everything can happen all the way up to closing
After
after.
too.
After.
But it's life of an estate, like the estate can be weeks, months, years in the making. It
So
can
even
close
after
and it can
closing.
reopen.
So is that something we should notify and tell our buyers if they're purchasing a estate, that there could be an issue of something coming up after the fact, or is their title insurance gonna?
I mean, that's like warning your buyer that there's a potential for the hurricane to knock it down before closing too. I mean, you can't
It's not necessary.
counsel on every single
Right.
risk possible. You gotta counsel for the ones that are the elephants in the room. The fact that it's an open estate is the elephant in the room. The fact that there could be a disgruntled person involved in that family is less of the elephant in the room there.
Gotcha.
Right, so
Okay.
when I do a closing, when there's an estate involved, and of course, I always counsel people to get title insurance. I will tell them, you got title insurance, so what this is gonna do is it's going to protect you. If anybody comes up and says that they were a long lost heir, that they should have gotten a share, that they should have gotten this or that. So title insurance will protect them if they got it.
Gotcha. Okay. Anybody else have anything else? Well, guys, thank you so much. I'm sure, anybody online have anything?
No, you're good.
We're good, okay. That, I'm sure, somebody will reach out to you because the question will pop into somebody's head here, go, I should have asked that, so I really appreciate it. Oh, yes, what is this? This is
The commission's flow chart.
Oh, the flow chart, I was like, what is that? Now I know. So there is put out by NCREC, it is the flow chart for the, that's why Kim was back that way. It is a flow chart for the estate property flow chart. You can get this from NCREC, it's standard form 10T. so you can pull that up and it'll kind of help you with the steps. And then also want to remind everybody that we have, a couple classes coming up. Be sure to go on Longleaf Pines website and check on it, and we do have our Realtor Rally coming up on September 17th. Go ahead and get your tickets. For any of you, if you'd like to be a vendor there, we would love to have you, as part of our rally. Did I miss anything else? All right, guys, thank you so much. We appreciate everything.
Thank you.